Welcome, curious minds, to the deep dive. Today, we're navigating something really crucial if you're renting here in California. We're talking about the big updates to landlord-tenant laws coming up for 2025.
Yeah, it can definitely feel like a bit of a legal maze sometimes.
Totally. But our mission today is basically to hand you the map,
Yeah.
so you can walk through it feeling confident.
Exactly. We've spent a lot of time digging through detailed legal analyses, government info, and how these rules actually play out on the ground. Our goal is really just to break these updates down into plain English so you know exactly what's changing, why it matters to you as a tenant, and importantly, how you can maybe use these changes.
Right. We're getting into everything from how paying your rent might actually, believe it or not, help your credit score, to new rules about security deposits, and even getting more time if you're facing something like an eviction.
Yeah, get ready for some moments,
Mm-hmm.
because a lot of these updates are really designed to give tenants more power.
So what does this all mean for you? Let's unpack this. All right, first up, let's talk about AB 2747. This one, it really has the potential to change how your rent payments affect your finances. It could let your rent actually build your credit.
Yeah, what's really interesting here is that this new law, it actually requires certain landlords, not all, but certain ones, to give you the option of reporting your on-time rent payments to credit bureaus.
So it's not just a maybe, it's like a new right you have.
Pretty much, yeah. It's a new right for many tenants.
Okay, but who exactly does this apply to? Because I'm guessing it's not, like every single landlord.
You're right. It's not everyone. It's generally aimed at the larger players. Think landlords who own buildings with 15 or more units, or maybe they operate as a corporation or a REIT owning several properties. Your smaller sort of mom and pop landlords, the ones with maybe 15 or fewer units and aren't part of some big company structure, they're usually exempt from this.
Gotcha. So if I'm signing a new lease soon, when does this kick in, and what if I'm already renting?
Good question. So for new leases starting on or after April 1st, 2025, the landlord have to offer you this option. If you're already in a lease, they still need to let you know about it at least once a year. Now, they can charge a fee for this reporting service.
Ah, okay, there's the catch maybe.
Well, kind of, but it's capped. It can't be more than $10 a month or with whatever it actually costs them to do the reporting, whichever one is lower. And if it costs them nothing, they can't charge you anything.
Okay, that's important. But what if I decide, I don't want to pay that fee? Can they get mad, try to evict me?
Nope, absolutely not. That's a crucial point. They cannot penalize you or try to evict you just because you didn't pay the reporting fee. That fee is totally separate from your rent. Now, if you don't pay that specific fee for, say, 30 days or more, they can stop reporting your positive payments. But it doesn't affect your tenancy itself.
Huh.
And the sort of why now for this law, it's pretty clear, right? It's trying to help out millions of renters who pay this huge bill every month on time but get zero credit benefit. It's trying to fix that imbalance.
That really is a game changer. You're already paying rent, might as well get credit for it, right?
Wow.
Helps you build a stronger financial future without needing another credit card or something.
Exactly. It's about empowerment.
Okay, moving on. Let's talk application fees and screening. AB 2493 brings in some very specific new rules here.
Yeah, this sounds like it's aiming for more transparency. That whole application process can feel like a black box sometimes.
Yeah.
So landlords have to pick one of two ways now.
That's right. They have two choices. There's the sequential application process, some people call it the MEA method, or there's the refundable screening fee process, which is kind of like a job interview method. And this brings up a really important question for you, the tenant. You need to know which method your potential landlord is using.
Okay, let's break those down. What's the sequential MEA method? Right, so with the sequential method, landlords must process applications in the exact order they come in. First come, first served, basically, if you qualify. And, crucially, they have to give you clear written criteria up front, so you know exactly what they're looking for before you pay anything. The first person who applies and meets all those criteria gets the place.
Okay, and refunds. What if I apply but someone else qualified first?
Good point. If you weren't the first qualified applicant, the landlord has to refund your fee within 7 days. Or they could offer to apply it to another one of their available units if you agree. Now, if you applied but didn't meet those upfront criteria they clearly told you about, then they can keep the fee. The idea here is to stop landlords just collecting fee after fee from people who never had a shot.
That makes a lot of sense. Okay, what about the other way, the job interview method or refundable screening fee? That sounds pretty good for tenants.
It definitely leans that way, yeah.
Yeah.
Under this method, it's simpler in a way. The landlord has to refund the application fee to everyone they don't end up choosing. Doesn't matter why they didn't pick you. And the refund has to be quick, within 7 days after they pick someone, or within 30 days after you applied, whichever happens first. It kind of pushes landlords to be more careful about who they screen in the first place.
So either way, the big takeaway seems to be transparency, right? Ask up front which process they're using.
Exactly. Know the rules they're playing by.
And knowing you get a copy of your credit report if you pay the fee is a nice little bonus, too. It's really about managing your expectations and, frankly, your money when you're apartment hunting.
And if we sort of connect this to the bigger picture, there's SB 611. This is a pretty big win for tenants because it directly bans several common, let's call them junk fees, that landlords used to be able to add on.
Junk fees, right. Trying to get rid of those hidden costs that just pop up out of nowhere. What kind of fees are we talking about here?
Well, for example, landlords can't charge you a fee anymore just for serving you a legally required notice, like a 3-day notice to pay rent or quit.
Wait, they used to charge for that?
Sometimes, yeah. The thinking now is they're legally required to give you that notice. Why should you pay for them to do their job? They also can't charge you a fee just for paying your rent with a regular check. And there's a specific protection for service members, too. If they paid extra fees because of poor rental history, they get those refunded after 6 months of paying on time.
Okay.
It's all aimed at making the cost of renting more predictable, more fair. The why now seems to be just a legislative pushback against these sort of nickel and dime fees that really frustrated people.
Okay, this next one, SB 105.1, feels incredibly important. It's about safety, security for tenants in really tough situations.
Yeah, this one is critical. SB 105.1 provides really vital safety measures, specifically for victims of domestic violence. If you or an immediate family member or even someone else living with you is a victim, and you can provide proof to your landlord, things like a police report or restraining order, the landlord is now legally required to change the locks on your apartment within 24 hours.
Wow, 24 hours, that's fast.
It has to be. And here's a really powerful part. The landlord has to pay for the lock change. The cost doesn't fall on the victim. It really prioritizes safety above all else.
What if the landlord doesn't do it? What if they delay or just ignore the request within that 24 hours?
Great question. If the landlord fails to comply, the law empowers you to change the locks yourself.
Really?
Yes. But you have to notify the landlord within 24 hours that you've done it, and you have to give them a new key. Then the landlord has 21 days to reimburse you for the cost you incurred. And maybe even more powerful, landlords are prohibited from retaliating against you for using this right. They can't deny your rental application later or add weird conditions just because you needed your locks changed for safety. This law really closes a dangerous gap.
That's incredibly powerful. It shifts the burden and puts safety first. Huge.
Okay, let's pivot to something almost every renter deals with. Security deposits.
Yeah.
AB 2801 and AB 12 are bringing some pretty big changes here, mostly focused on accountability and transparency. But this really raises the question, how can you, as a tenant, better protect your deposit using these new rules?
Right. So AB 2801, this one phases in through 2025. It's all about photos, right?
Yeah.
Like documented proof.
Exactly. It requires landlords to take photos of the rental unit right after you move out, and crucially, before they start any cleaning or repairs.
Before. Okay, that's key.
Yes. And for new tenants moving in, they also have to take photos before you move in, so you have a baseline. And they don't just take the photos, they have to give them to you. Date-stamped photos from move-in, from move-out, and even photos taken after any repairs or cleaning they did that they're deducting for. All that comes with the itemized list of deductions when they return your deposit.
So much harder to argue about what was already there versus what happened during the tenancy.
Precisely. And speaking of deductions, there's a specific point about carpet cleaning. They can only deduct for professional carpet cleaning if it's genuinely necessary to get the carpet back to how it was when you moved in, minus normal wear and tear, of course. They can't just automatically charge everyone for carpet cleaning anymore.
That old automatic charge, glad to see that addressed. It should really cut down on disputes over damage versus just, living in a place.
And then there's AB 12. This one actually started July 1st, 2024, but it's super relevant for 2025 and beyond. It puts a cap on security deposits.
Yes, the cap. What is it now?
It's limited to 1 month's rent. That's it. For both furnished and unfurnished places, which is a pretty big deal, reducing that upfront cost of moving in.
1 month's rent, max. Wow. Are there any exceptions?
There's one main exception, yes. For small landlords. That's defined pretty specifically folks who own no more than 2 residential rental properties, and those properties together have no more than 4 units total. And they have to hold them as an individual, a specific type of LLC, or a family trust. Those landlords can potentially still ask for up to 2 months' rent.
Okay, small landlord exception. Good to know.
But, and this is important, the small landlord exception does not apply if the tenant is an active military service member. For service members, it's always capped at 1 month's rent.
Got it. And the why for AB 12 seems pretty obvious, right? Housing affordability?
Absolutely. It's directly aimed at easing the financial burden on tenants entering a lease in California's extensive market.
So these photo requirements and the deposit cap together, that really feels like it levels the playing field quite a bit for tenants when it comes to getting that deposit back fairly.
Definitely. Okay, this next one, AB 2898, deals with parking. Seems minor, but it actually affects your housing security. It's about unbundled parking.
Unbundled parking. Yeah, I've heard that term. What's the change here? Sounds like it might be fixing a weird loophole or something.
You could say that. The main change is simple. If your landlord charges you for parking or has any kind of parking agreement with you at all, that agreement now has to be in a completely separate document from your main residential lease.
Separate. Okay. Why? Is it just paperwork or is there a bigger reason?
Oh, there's a much bigger reason.
Yeah.
It's all about protecting your actual housing. By separating the parking agreement from the lease for your home, it prevents a situation where a landlord could try to evict you from your apartment because of an issue related solely to parking. Like say you were late on a parking fee or violated some parking rule.
Okay. So they can't use a parking ticket issue as grounds to kick you out of your home.
Exactly. Your housing tenancy is now legally separate and more secure from minor parking disputes. It's a strategic move to stop that kind of leverage.
That's actually really smart. You wouldn't immediately think your parking spot could jeopardize your lease like that. Good change.
And finally, let's touch on a critical change to the eviction process itself. AB 2347. This one modifies the timeline for responding if you receive an eviction lawsuit, which is formally called an unlawful detainer.
Okay, the unlawful detainer response time. How much does it change? Because I know it used to be really fast.
It was incredibly fast. It used to be just 5 business days to file your formal response with the court. That's barely enough time to understand what's happening, let alone find help. Now, under AB 2347, you have 10 business days, double the time.
10 business days. Okay, that sounds significantly better.
It really is. That extra time can be absolutely crucial. It gives tenants a realistic window to actually seek legal advice, figure out their options, understand the claims against them, and prepare a proper defense. While the bill did make some other parts of the process slightly faster for landlords, this extended response time is a major benefit for tenants facing that incredibly stressful situation.
Yeah, that extra week could honestly be the difference between keeping your home and not. It gives you breathing room, a chance to actually fight back if you have grounds.
Exactly. Now, while those are the big new laws and updates for 2025, it's really important for tenants to remember these don't exist in a vacuum, right? They build on protections that are already in place.
Good point. Like the Tenant Protection Act of 2019, that's still a big one.
Absolutely. The TPA, which was also updated by SB 567, effective in 2024, that's your bedrock for just cause eviction protections and rent caps in many situations.
Right, just cause. Meaning, after you've lived there lawfully for 12 months, your landlord needs a specific, valid reason to end your tenancy.
Precisely. Either an at-fault reason you didn't pay rent, seriously violated the lease, caused damage, etc., or a no-fault reason, like the owner or their close family wants to move in, or they're taking the unit off the market for major renovations.
And those no-fault reasons have strict rules too, right? Like relocation assistance.
Yes, definitely. For most no-fault evictions, the landlord usually has to provide relocation assistance, typically equal to 1 month's rent. And the TPA also includes the statewide rent cap. Generally, increases are limited to 5% plus inflation of the CPI, or 10% total per year, whichever is lower. It's a key defense against huge rent hikes.
Okay, and beyond eviction and rent, what about just the basic condition of the place, the right to a safe home?
That's fundamental. Covered in the warranty of habitability, mostly in Civil Code 1941.1. Your landlord must keep your unit in a habitable condition. That means safe, livable, working plumbing, hot-cold water, heating, safe electrical sound structure, locks on doors and windows.
Smoke detectors, pest control, all that basic stuff.
All that basic stuff. And if something's wrong, put your repair request in writing. Email, text, letter, keep a record, take photos or videos.
And if the landlord just ignores you?
Your next step is often contacting your local code enforcement or health department. They could inspect and legally require the landlord to make repairs. And remember, it's illegal for your landlord to retaliate against you just because you asked for repairs or reported a problem.
Good to know. Now, I remember hearing something about a big push for even stricter rent control that didn't quite make it for 2025.
Yes, you're probably thinking of AB 1157. That bill aimed for tighter statewide caps, maybe getting rid of exemptions for single-family homes. It faced strong opposition, including from some housing groups worried it might actually discourage new building, and it stalled. So those stricter measures are not law for 2025. The existing TPA caps remain the standard.
Okay. And one last quick update, something about balconies.
Right, just a deadline shift. The mandatory inspection deadline for balconies and similar structures on apartment buildings, AB 2579, got pushed back a year to January 1st, 2026.
Yeah.
Just gives building owners a bit more time to comply with those safety checks.
Wow. Okay. That was genuinely a deep dive. We covered so much ground on California's tenant protections for 2025 and even the ongoing rules. Everything from using your rent payments to build credit, getting clarity on application fees, the ban on junk fees, crucial safety for domestic violence victims, those big changes to security deposits with photos and caps.
The separate parking agreements, the extended eviction response time.
Yeah,
a lot.
the whole lot.
And the big theme running through so many of these updates really seems to be increasing transparency, boosting fairness, and just providing stronger, more practical protections for renters all across California. Knowing your rights, understanding what your landlord is now legally required to do it, can honestly make your whole renting experience feel much more secure and, frankly, less stressful.
Exactly. And just as a resource note, if you happen to be in Orange County, Riverside, San Diego, or LA, and you find yourself with specific questions about things like eviction defense, unlawful detainers, or just understanding your rights as a tenant, places like martinezlawcenter.com focus specifically on helping tenants navigate these issues.
That's a great point. And maybe this leads to a final thought for everyone listening. Considering all these new rules and protections we've discussed, how might you approach things differently now? Like when you're looking for a new place, or even just interacting with your current landlord. What new questions might you ask? What things will you look out for that maybe you didn't even know were things to look out for before today?
That's a really powerful takeaway question. These laws are there to help you, to protect you. So take the time, figure out how they apply to your situation, because knowledge really is power, especially when it comes to your home. Thanks so much for joining us for this deep dive. Remember, everyone, stay informed, stay proactive, and know your rights.
Call now 714-442-9741. Thank you.